There we go. Thank you for the heads up on that. I was talking away. Um, so we're gonna finish off chapter 10 today, and then move on to chapter 12, which is criminal justice system. So we're gonna finish interest groups. I think I'm gonna recover a little bit of this last slide here on managing the size of interest group and the success of an interest group. Then we'll talk about the free rider problem and then move forward. Um, we did touch last time on the issue of size for an interest group and uh, how an interest group is trying to be successful is um, sometimes dependent upon the size of their interest group or the um, impact that they can make if they're pretty efficacious as an interest group. So a lot of groups are so focused on a particular issue that they don't necessarily have to have the biggest size. They need to be um, experts on whatever their issue is, certainly. But um, in that sense, they don't have to actually chase their making their actual group as close to the potential group as possible. So it is, in the best interest of a group to figure out what their best size, most functional size, most effective size is going to be. If you're an interest group that's made up of large multinational corporations, those corporations are going to come online as soon as they can because you'll be working for their benefit. And they've got enough clout, they've got enough market size that they don't have to worry about their membership size. Um, the more you get closer to social issues or issues that affect mainly the public, then issues about size matter. So uh, you want to, as a group, represent all Texans or most Americans or all people that are 55 or older, right? Then you need to have a group probably um, that is trying to be as large and as influential as possible. So, right, and that's as we talked about before with like American Association of Retired People, massive interest group, right, trying to represent all the old people, 50 and older in the United States. Their interest group is, 30 million people thereabouts. Um, that's the size, that's their membership size. And that makes a difference for their lobbyists whenever they head in to actually engage in lobbying. But again, if you're a business interest group and there are a limited number of businesses, you just need to make sure that you're representing that whole business arena. Um, the other thing that you got to look at here is how you're going to manage that group, right? And we talked some about this last time, but um, you have three different types of benefits as an organization that you generate, right? You generate first and foremost a policy or goal oriented benefit, the reason that your organization exists, what they're trying to do. Second, coming out of that is a the social or like-mindedness of having a group of people that are all rowing the boat the same direction toward the same goal. And so that's a benefit because people like to belong and they like to be around people that are like-minded, right? They get along with those folks. And then third, you will bring in as needed material or tangible benefits to try to encourage people to be uh, that are maybe debating whether they want to join or not. Something like a tangible benefit, discounts or a book or a hat, or something might push them over the edge and just make them choose to join your organization, right? And to share their limited, probably, dollars and resources they have, and they're having to kind of look at who do I join? Um, and when we're talking about those types of people, that brings us to an issue that we need to be recognizing and paying attention to, called the free rider problem. Uh, so Manker Olson, right, theorist kind of pointed out that anytime you're looking at an interest group or any kind of social group that's trying to move forward, um, part of what you have to do is manage the size of that group. And if your interest group, if their goal, right, their public policy goal is to provide a collective good, right, something that benefits everyone, like clean air, then you've got an issue because um, rational actors are going to look at you and go, okay, I want the purpose of this interest group to be met. I want there to be clean air. But I can also recognize that if that group is successful in chasing that goal or that policy and we get clean air, it's not a resource that they can manage, right? Everybody gets the result. Um, New policy gets pushed through and the government is chasing clean air. Everybody gets to breathe the clean air, whether they belong to the group or not, because the scope of this thing is a collective scope, right? So clean air, clean water, protecting the environment, protecting animals, um, anything like that, where you're going to, the benefit is shared, whether you belong to the group or not, represents a real problem for interest groups because now they've got a subset of people out there that they want to join their group, but what they're doing may not be a big enough impetus to make them join that group, right? So um, if I can be what Manker Olson declared as a free rider, um, it makes sense for me to do that as an individual, especially if I'm having to choose where to put my limited amount of resources as an individual. If I'm choosing between uh, putting my money, my membership, my time, my effort to an interest group where there's a very small potential membership pool, and where you have to kind of be a member to get the results. And I'm balancing that off against whether I send my monies to a group that is providing the collective good and I will get the benefit whether I join or not. You can see how it can be a pretty easy and economical decision for me to maybe go with the smaller group that definitely needs my help and whose benefits I can only get if I'm a member. And so Manker Olson says, hey, you got to recognize, based upon the purpose of your group, that you may be putting yourself out here in a place that's hard to manage membership, and it's hard to get people to join based on purpose or on solidarity. So in those kind of situations, you might be forced, if you're having a membership issue, a size issue, you're not getting to the scope you need to be impacting policy, you might have to bring in material benefits that are provided only to members. And when you do that, we call those selective benefits, right? You're having to spend time, effort, money to encourage your membership to join by giving these other things. And so if you're chasing a collective or a public good, then it's going to be a more expensive, more delicate process of trying to manage your membership, um, as opposed to those organizations where their purpose, when it's met, is a selective benefit already. So this free rider problem could be, um, for interest groups, a big issue, right? And so um, it's something that has to be considered based upon what you're trying to do. Um, and in that sense, it's just another task, another part of managing your secondary goal to help you be successful in meeting your primary goals and interest group. Does this make sense? Okay. That brings us to our last slide in this chapter. These theories of democracy that you see here, right? Pluralism, hyperpluralism, and elite theory, which is not really a democratic theory, but these three theories, right? We talked about these much earlier in the semester, kind of the very beginning, and I talked about how if a democracy is going to be successful, it needs to be pluralistic in its design, which means it lets, right, it has doors or windows or opportunities for people, individuals, to get involved in the political process, to say what they need to say, to try to convince people to believe what they believe. And a system that provides those kind of things is a better democratic system because people can get involved. And if you remember, we talked about as an example, right? You're on a major highway. It's 3 a.m. in the morning. That resource works for you. There's lots of opportunity there. You can move through with no problem. But when everybody realizes this is a good resource and everybody starts using it, right? And here we're trying to draw the illusion to pluralism in America being in Texas being a successful uh, product, a successful process. More people are going to jump on board. More people are going to get involved. And our folks that have looked into democracy and how it works have been telling us a long time, that um, our system is open. Interest groups and voters and political parties and media all have plenty of access provided by the structure of the system to get involved in this democracy and try to make a difference. Um, and what we have from descriptive political theorists looking at democracy is actually, right, the argument that there is probably hyperpluralism, that our systems are so open for participation that there's too many demands being brought into the system, too many people or interest groups or whatever are making demands on the system about what they want, and the system can't handle all of that. And we refer to that as hyperpluralism, right? Pluralism that has become so hyped up that the demands are overwhelming the system. Um, and then if you remember, we had the third discussion about democracy saying maybe it's not even really that functional at all, that it's really just a continual effort and struggle between either, the elites and the non-elites, or the haves and the have-nots, right? Fighting over resource, fighting over using government, fighting over policy. And it's not really a situation, right, where you've got an open process for everybody. I mention this and bring this back up on this slide now because these three theories actually have more of an impact or more critical when you look at them from interest group participation in politics. Um, there are thousands, literally thousands of interest groups in Texas that are trying to influence the political system, bring information into the system, try to get legislation that will meet their policy perspectives and ideas. I've mentioned in the past that, we have 6, 8, 10,000 bills, right, submitted every legislative session. And a lot of those bills are bills that are crafted by interest groups and are shared with legislators who support that idea and support that perspective, and then submit that bill into the legislative process. All of this is coming in, right? All of these demands, all of these uh, different perspectives, and are being driven into the Texas legislature, the U.S. federal system, right? And so these theories here of pluralism and hyperpluralism and elite theory come back into play, um, and need to be thought about not just as how individuals get involved, but it's how groups are involved in the system, how groups are making demands upon the Texas legislature and the bureaucracy and the executive branch in Texas. Um, when there's as much money and as much interest and as much organization as we have in Texas, right, between these social interest groups and business interest groups, that's an awful large uh, load, right, that gets put on the system. Um, and so we need to realize that these theories play right back in and fit in real well with interest groups and interest group theory and how the game is of politics is being played by these political actors. Any questions about that? Okay, so let's move um, to the criminal justice system. Since I don't see any questions, make sure my share is showing you the right thing here. Yes. Um, so chapter 12 is an extended look at the criminal justice system in Texas, and it talks about a lot of different places and actors within this. Um, we've talked about some of this, right, already in different chapters. So we're going to look here at the components of this. We're going to talk about how the system kind of works, how it will impact you. The main three components of this criminal justice system are the law enforcement and the prosecution wing, right? So those folks that arrest you and those folks that bring your case into the court system. The second is the actual court system itself, criminal trials, criminal appeals. We talked about that right in its own chapter. We're not going to cover that again. And then we briefly touched on the correction system. We're going to go a little bit back into some of that as we look at what's going on here. Um, so let's talk about the law enforcement part of it, the front end of it first. Um, Texas Constitution, which we've talked about before, touches on law enforcement and says that there will be a sheriff in every Texas county. So 254 counties, 254 sheriff. Each sheriff has deputies that work with him. Then we talked in the past about when we're talking about local governments, how the state constitution allows there to be municipalities chartered in Texas. In other words, the creation of um, uh, municipalities or cities, and those cities, right, have the authority, both as general law cities and home rule cities, to have police departments. And so you get law enforcement coming in through all the incorporated cities in Texas. I have on here 1,200. There's probably more than that now. Um, so we're looking at well in excess of 1,400 different law enforcement entities that have some kind of jurisdiction within the state of Texas. And then we have our Department of Public Safety, which is our statewide um, system, right? That of police, and they do a lot of different things, right? Manage the Capitol Police that protects the state capitol. They do traffic enforcement across the state, right? They have uh, the um, Rangers, Texas Rangers, that do the in-depth criminal investigations, right? Considered probably one of the best investigative units in the country. Um, so that's all working at the state level. So there's a lot going on here. We talked about the court systems, right? So we've already looked at all of the structure of the different courts and how they come together and how cases can move through appeal through that. Um, So we've looked at that hierarchy there, and we've looked at where the courts are and how they stack up and how you can come in at the county level or precinct level. You come in at a district level. That we talked about there being overlapping jurisdictions between that and that being an issue. So you've been exposed to that. And the third element here is um, the correction system. And the correction system, right, is our prisons and our jails in Texas. And so this is that whole organization that deals with incarceration and pardons and paroles. And so we're going to talk about that as we move through this chapter. And we're going to do this by looking at the different steps of the criminal justice system in Texas. So we're going to move through um, these 9 elements of the process and talk about what comes in where. And there's going to be some court cases here, and we'll talk about each of these at least a little bit. So most of our, as individuals, most of our interaction with the criminal justice system is going to be either in an arrest or a search situation where we're coming into contact with individual officers, right? And so if it's an arrest situation, um, that's going to be one of 2 ways. The best way to be for this process to occur is for there to be evidence brought before a magistrate of some kind, and then that magistrate, that judge, issues a warrant for an arrest, right? And so a warrant means that um, the investigative arm here, the police, have brought evidence, which we would refer to as probable cause of some crime being committed, and evidence that that crime that was committed by an identifiable person. And then that warrant would be issued by the judge saying, go arrest this person. Probable cause has been met that they are right, most definitely an interested party in what's going on here. And so that arrest warrant would be issued, and um, the government will have gone through a process, right, of trying to ensure that before they take you off the streets, before they arrest you, before they come, right, and interrupt whatever you're doing, that they have, right, met a procedural perspective that says, yeah, this is a good act by the government. This makes sense. And disinterested party has said, Judge, we should do this. And that'll start off the process. Police do not have to have, right, a warrant to arrest someone. If they are in a situation where they have established probable cause and they believe that waiting would be an issue with whether they could arrest someone or not, they do have the authority, as we see quite often, to arrest people, and they have to establish that probable cause as they bring that person in. That can be right, right, a barrier for them, but it's one that, as a functioning democracy, right, we should require them to be able to establish. They can't just constitutionally just take someone off the streets, right? And I say constitutionally, right, because I'm talking about the appropriate process here. We know from experience, we know from watching the news that sometimes they do, and the reason it's news is because they haven't established probable cause or they don't have probable cause, and those kinds of takings are considered unconstitutional or illegal. So, right, the police must meet a certain standard of probable cause, even if they don't have a warrant that says there is probable cause. And then that will occur on the back end of things. Arrest then brings you An arrest is where they have officially detained you and said, right, we are limiting your freedom, and you're going to go down and uh, meet with a judge eventually. So upon arrest, right, you're going to be opening up the situation where some kind of search can happen. Um, you can also have searches prior to arrest, but you are going to be searched. Your person will be searched upon arrest. We've got reasons for, so at least safety reasons for sure, for the police to be able to engage in search after they have arrested you. Right, they're going to take you downtown. They can right make sure that this is going to be a safe situation. Although in other cases, we do have constitutional protections against um, warrantless searches, right, or non-arresting searches, either one of those. The police don't just have the authority to walk up and search you and your surroundings unless you give them consent or they have that um, probable cause that's going to lead them possibly to an arrest anyway. So warrantless searches can be reasonable. Warrantless searches um, usually are going to still be surrounded by the idea of safety, right, for the police officer and everybody involved in the situation. So let's say you've been pulled over and the police officer is talking to you through the window of your car or whatever, um, and they decide that you know you need to get out and they need to arrest you. They're going to search the immediate surroundings of your vehicle to make sure that you don't have a weapon that you're going to be bringing into the situation, something like that, right? And they're going to that's going to be a condition or an activity that the courts will uphold. Um, that immediate surrounding justification, um, right? Once the immediacy of it is gone, once you're outside that realm of where the individual could reach, then that warrantless search is probably right. The further you get away from that, the more troublesome it becomes. Um, and the more they need to probably go get a warrant to conduct a good search. Because right, the Fourth Amendment gives us protections, right, against warrantless searches, warrantless seizures. And so they're looking at the Constitution on one side as a limit on their abilities and a protection on our rights. Um, Keep in mind, however, that any police officer that's following their training is going to ask you for permission to search. Um, if you give consent to a search, any search, um, then that's right waives the need for a warrant, uh, and so that's a situation that's going to come into play here. So the Fourth Amendment here, right, from the U.S. Constitution tells us, right, that we have a right. In this sense, right, read this to be a civil liberty, not a civil right. We use the words interchangeably a lot. Um, so this is a civil liberty, which means a protection from the government. Um, we have a right to be secure in our persons, right? That means our bodies, our houses, our papers, our effects. That means our stuff, right? Right to, unreasonable searches, unreasonable seizures. Those, right, that right cannot be violated. No warrants shall be issued but on probable cause. So when we talk about there being cause, right, the Constitution is laying that out. Supported by an oath or affirmation, and particularly describing the places to be searched, the persons, and the things to be seized. So warrants are not just a yes, go look anywhere, right? The uh, criminal justice system, when they are dealing with this, right, they must be following, right, this constitutional, this Fourth Amendment to the Constitution saying, hey, if we're going to violate someone's constitutional rights here, we've got to meet a certain threshold. And that threshold in this case is to be clear and direct and specific about what's going on, where we want to be, what we expect to find, and why we expect to find that there. And it has to be convincing, ideally, to a judge to sign that warrant saying, yes, you, the state, you, the government can go to this place and look for this thing because we have probable cause or some kind of supporting evidence that it exists there. There is a crime occurring there, right, in this place. And so, in that sense, search and seizure can then move forward. Um, this is the best case scenario, right? Now, the courts have then ruled later that there can be warrantless searches when you, right, or as the police are concerned that the crime is happening. And if you had to go to the court to get the warrant, everything would fall apart or someone would be injured or the evidence would go away. So you are given, right, the opportunity to move in without a warrant. Um, you have to then, in the background, after this action is over, fulfill still all of the criteria of this and show why a warrantless search was immediately needed and why you couldn't get a warrant and that you did the same things you would do if you had a warrant, that you limited your search to what you knew was the case and what you had evidence of. And so um, the Fourth Amendment gives us protections against government overreach when uh, police and prosecution are moving forward to make a case against an individual for some kind of perceived bad action. And so we're continually weighing in the criminal justice system, right, how that's going to be the case, right? When it's proper to go in without a warrant, or could you have gotten a warrant? Um, did you, uh, right, follow the process appropriately? Um, Court has ruled in a case called Miranda that we are free from, should be free and should be protected from unreasonable searches and seizures. Um, those Miranda rights that came out of the case are ones that should be making us aware of our rights and aware of our protections so that we can uh, act in our own best interest and protect ourselves from possibly overreaching government officials and actions. Um, so this all occurs on the front end where you've got right an arrest and then a seizure and a search. Um, so to put this into a context, right, where you might run into this, just think about a stop, a car stop on the side of the road where a police officer is going to come up and engage you. Maybe you were, let's assume that there was some legitimate reason to pull you over, say you were speeding and they pull you over for speeding, right? The whole concept here is that they witnessed an action contrary to the law and they're going to issue you either a warning or a citation of some kind for your action. When they come up to you now, right, you've got the police and you as an individual interacting. And there, of course, are well on alert for looking for any other illegal activities or evidence that there is something going on. And they're going to maybe, right, want to search around your immediate surroundings to make sure that you don't have something that can endanger them publicly. They may not, right? The situation may be very low key and they may not feel that that's an issue, right? But if they chose to exercise that, that means that they could probably search in your vehicle anywhere that you, as a subject, could reach without a warrant and be under this kind of a safety exemption for them. But if they were to ask you, can I look in your glove box or can I look in the trunk of your car? Um, that's now them asking for your consent to search because they probably, unless right something else is going on, do not have uh, probable cause to do that, right? So you could be pulled over for speeding, and right, police officer could be working through the signing the ticket to you or whatever, and then they may just ask, "Hey, mind if I search your trunk?" They're asking you for consent. They're asking you to waive essentially your protection to searches and seizures given to you the Fourth Amendment. And if you say yes, then you've waived that right, right? And anything they find then is evidence that could be used against you, right? Um, so I'm not going to tell you to not do that or do that, but be aware that consent absolves them of having to make their case if a warrantless arrest comes out of that situation. Um, your best, although not very convenient, answer would be to deny them consent to search. Period. Just say no. I don't grant consent. You don't have to give a reason why or anything like that, right? It's your right. You can exercise it. Right. This opens up a whole lot of potential issues here, right? If you have a bad cop who, right, things can go sideways. If you get a good cop, then they're fine with that, right? Um, and that's as y'all all well know, probably a situational kind of thing that you're going to come up against and have to think about if you're going to exercise that Fourth Amendment right to prevent a seizure or a search. Um, I know that attorneys will tell you to always strenuously protect your rights, your liberties from government overreach. And ideally, that's always the best answer. Um, I am not an attorney and I cannot give you any kind of legal advice. Um, I just know that it's not as simple as knowing what's supposed to be the case and what the law is. Okay, so that's the arrest kind of search procedure that goes on at the front end um, of an encounter that goes bad for you as an individual and is bringing you into the criminal justice process. The next step is going to be a booking process. Um, this is a very important part of this, what's going on here, because this is where all the initial administrative record of who you are and what charges are and what evidence is. Um, right. All of this is where this gets administratively recorded. Um, and everything's going to happen after this is going to continually reference what was recorded at this point. This is where they're going to book you as an individual. They're going to read you your rights. They make sure your rights have been read to you. They're going to take photos and fingerprints and right that you were arrested. One of the things that this process, the reason this process is the way it is, and we don't think about it a lot of times, is because um, if you go back to the right U.S. Constitution, right, it actually says in the Constitution that you have protections against being held without any notice being given about it, that being thrown into a jail situation where you're not told what the accusations are against you, um, that you can be held indefinitely. Right, we're going to talk about all of these things. Right, and the Constitution lays out not just in the Bill of Rights, but actually in the U.S. Constitution proper, right? A lot of these criminal rights that you have, and these were things that our founders were particularly concerned about because they had seen these things being mismanaged by the state before, and so um, you have the right to know these things, right? To see what that record is, to understand what's going into it, to notify someone of where you are, right, and what's going on. This is, right, I say here, this is where your phone call is around, that phone call that you can make to a family or to an attorney or something, right? But the system, the government, has to allow you as an individual to reach out and make sure. And this is one of the things we're right having big issues with ICE, right, and how they're uh, apprehending people and taking people in, is that the Constitution gives all people, right, not citizens, but all people, right, this process that must be followed so that people don't disappear, um, so that family, friends, and society know what the government's doing with and to people, and that we know where people are, we know why they were picked up, that right there are public recordings of all of these actions that's going on. Right, you can go down and read, right, the logs of the police department and who they arrested and brought in and when they released them or not, what their bail is, right, and that we'll get to bail in a minute. um, all of these steps, right, are supposed to be easily witnessed, clean, above board kind of procedures, so that, right, we always have an accounting of what the government is doing when they believe, right, that you are a criminal and need to be brought into the system. So there are all these checks and balances are very important. Um, so the booking process starts all of this, right, in a real sense for you, um, and for the people that care about you and know where you are and what's going on. Um, there is never a case uh, where someone should be brought into the criminal justice system and there is not a record of when, why, and where they are. That should never happen. If it does, some legal process has been missed or hidden, right? Um, when we take rights away from people, when we abridge people's rights given to the Constitution, and there are good reasons to sometimes, right? When we're looking at especially the criminal justice system, people have done bad things. Um, we still need to make sure all of this is well documented. All of this is making sense. Um, in this process, you're going to be charged with one of two types of crimes, a misdemeanor or a felony. Misdemeanors are the low end of the criminal spectrum of activities that can are crimes, right? It's and take this with a dose of salt here, right? It's relatively minor, right? Crimes. That doesn't mean that, right, that's the person that's happened to wouldn't consider this a big deal. They might. Um, but in the biggest scheme of things from the protected perspective of the state, we're talking relatively minor, usually property crimes or behavior crimes, usually nonviolent. Um, Stuff that is not good, that we have laws about, that we need to be applicable, but also not the really super bad uh, injury to a person, right? Um, Massive destruction of property, right? So things that are going to be serious issues that we have to deal with for the long term. We're talking about um, minor property crimes, theft, right, to a lower level, drug possession, but not necessarily drug dealing, right? But drug possession, public inebriation, right? Uh, Bad acting in public, things like that. So that would be a misdemeanor. The felony is your somebody's microphone is on, um, and I'm hearing your background noise. Um, okay, so felonies, right, are serious threats. Felonies are serious actions that we really expect the government to be involved in. Um, $5 theft or burglary, right, where there's breaking and entering, um, any kind of assault on a person, right, any kind of drug dealing, kind of such. These are the things, right, that are stepping up on the seriousness, on the criticality level. Um, Remember when we talked about courts in Texas? These were things, these felonies all came into the criminal justice system at the district court level. Um, right, the county courts were handling the misdemeanors, um, right, that existed below, which were still right. I mean, we don't want to short shrift the misdemeanors, but the felonies are pretty serious stuff, right? So, um, once it's established what the crime is, um, you're going to right that you're being charged with a felony, you're being charged with a misdemeanor, and here's the scope of the crime, and here's all of the recording of that and what's going on. So you're putting that record together. You're also going to be brought before a judge, a magistrate. Um, who does that depends upon where you're arrested, and who's charged with bringing those cases, criminal cases forward, whether that could be a county attorney, a district attorney, depending upon where the case is filed. But one of those folks is going to be bringing the charges, right, what you were arrested for, before a judge, before a magistrate. All of that information that has been collected and recorded by the police on the front end of the booking process and in the field when they were arresting you, all of that's going to be entered before the judge. The charges will be presented, right? They're saying here's what went on, here's who committed the crime in our opinion, here's what we've got in place. All that's going to be laid out for the judge, right? To have a clue of that things are going the right way, that this is a proper case, that um, right initial rights aren't being violated by this process. Um, the judge here is usually going to be making sure that all of the rights of you as an individual have been protected per case law and per constitution. So they're going to go through the process of looking at, was the arrest there? Did they have a warrant? If not, did they have the probable cause and the right circumstances to do a warrantless? They're going to be looking at this all at the very beginning, right? Just to make sure that they're following the process correctly. Um, so this is where your rights will be discussed between those bringing the case and the judge that's sitting there trying to not try the case, just trying to make sure that all these processes um, are are being followed properly. Evidence is going to be looked at this point, right? The district attorney, the county attorney, the prosecutor, whoever's bringing the case is going to be saying, "Hey, here's how we know we've got the right person and what the crime is, and that we've charged them with the right thing. Look at the evidence we got." If the judge works through all of this and sees that this is making sense, um, then they will move into a position of talking about setting a bail, right? And bail is, we'll talk a little bit in depth about this, but right, setting bail is the cost of setting you free prior to a trial, right? Um, the system wants assurances that if they let you out of jail, and for the lower end of the criminal process, right, they want to probably let you out of jail. Um, that you will then voluntarily come back into the process and engage in the court and your defense at a later time. Um, Also, this is going to be where the police and the prosecutors and the attorneys are trying to make sure that all of the witnesses, what they witnessed, and are that their statements are given, their statements are recorded, um, that evidence is preserved for later use at the trial. Like I said, now the Constitution weighs in on bail, and it specifically tells us that magistrates, courts cannot set, an excessive bail. Um, so right. What the excessive bail is difficult to really lay out. Um, but essentially, you're looking at the situation and you're trying to make sure that what you're going to ask for bail makes sense given the charges that are brought in. So, are you a flight risk? If you are, then bail may not be something that's going to be possible. Or if you're a minor flight risk, then you ask, right, set bail at a point that will be right, encouraging you to come back into the process. But the Eighth Amendment tells us that excessive bail shall not be required, nor shall excessive fines be imposed, nor cruel or unusual punishments inflicted. So the U.S. Constitution is telling the whole criminal system here um, that we should have moderate measures in place, right? No excessive bail, no excessive fine, no excessive or unusual punishments. And so all of that is reviewable about what's going on. The excessive bail part, though, um, you're the judge is looking at the disturbance that was caused by your actions or the potential property loss, right? What the circumstances of your action, what caused, and the cost of what you caused. Did you burn down a house? Did you crash a vehicle into a business? Did you steal, right, a vehicle or millions of dollars? Did you shoot and kill somebody? What the crime is has a large impact on whether what the bail should be and whether it will be considered excessive or not. Um, and this bail goes from zero to you don't get it, right, depending upon these circumstances. So you just have to understand that this is something that's supposed to be a measured response by the system um, that lets people um, not be incarcerated up until their court time if they don't have to be. Um, the other thing that comes into play here is the Fifth Amendment, right? So this is a long one, but this is what gets us to our Miranda kind of hearings and rights. Right, the Fifth Amendment says no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So that's telling you, right, that we need to have this political system set up so that at the very front end we have, right, judicial proceedings to determine if what's being done here is proper right at the very beginning. Um, there are exceptions there for military issue, but and war times to this grand jury process, but that's not a very large exception, right? For most of the time, right? If you look at what's someone is being accused of a crime, and the judge looks at it and says, "Yeah, there's a lot here. We should move forward." The step that is coming up is this calling in of a grand jury, and a grand jury's job is to sift through witness statements and cause and evidence and determine whether a trial should be held or not. So, one of the big protections we have in place for criminal accusations is that there's going to be some impartial body of people called a grand jury that's the court system brings together. And the prosecutor um, is the one that is, in a sense, put on trial. The prosecutor brings their evidence of a crime and how it's you, and they do a small presentation of the evidence in the situation to this grand jury. And the grand jury's job here is simply to say, issue what's called a true bill or a no bill. And a true bill is we, the grand jury, agree with the state that there is enough evidence against this individual to bring them into trial. Or a no bill is prosecutor, you didn't make sure that enough of this made sense, and we don't see the crime being permitted, or we don't see the evidence pointing to this person or something, but no trial. So on the very front end, we've built in this process um, to try to ensure that anytime the government is stepping in and limiting your liberty, that there are going to be these objective steps taken to make sure that it makes sense. And it's not just um, the government being a bad actor. The Fifth Amendment goes on to say that uh, nor shall any person be subject to the same offense for the same offense twice or be put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness to against himself. So that's your right to shut up. They may not be deprived of life, liberty, or property without the due process of law, nor shall private property be taken for public use without just compensation. That's your, um, um, I'm losing the word here, but when they condemn your property to be used for public use, they have to pay for it. Eminent domain is the term used there. Um, so, right, notice here that the words used here is very, very specific. And tells us an important scope of this Fifth Amendment. This amendment doesn't say no citizen. This amendment says no person, right? So these due process steps that we see in the Fifth Amendment and the Fourth Amendment, and, right, when you look at them, they say either person or citizen. And if they say person, that means anybody, right? Um, and the idea here from the founders was our political system, and especially our criminal justice system, should be impartial, should treat everybody the same, right? And should be following the same process every time for anybody that they bring before uh, this system, right, before the criminal justice system. Um, and then our Miranda rights as a um, are pulled out of these amendments, and then it's put upon the system to make sure that we as individuals know our rights before we go into this process. If you as a person don't know that you have the right to not testify against yourself, right, that's a problem. And so, right, at the point of arrest, right, we want you to be aware of these kind of things. Again, looking at what's going on in the country in the last year or so, especially with immigration, this is the charge, the concern that keeps being brought up. Are all persons who are being apprehended um, as having, right, being charged with breaking our immigration laws, are they being given the due process that the Constitution says every person is entitled to? Um, and that's the crux of a lot of uh, the protests that we see going on across the country against the immigration actions. Right, we've been continually engaged in immigration detainment in the United States. The reason this seems to be blowing up now is because the questions about our due process being followed for all of these people, as the Constitution says they should be. Um, and that's a big question. And it's one that if our democracy is going to maintain itself, it has to follow the rules. Um, so, right, the prosecutor brings the information forward. You go before a grand jury. That grand jury reviews all of the evidence, the crimes that are being there, um, and determines whether things move on to trial or not. Your grand juries are usually 12. In Texas, we also do have a petite jury, I think, that can weigh in on misdemeanors, lower, less serious crimes. But the idea is still the same, that you got to have, right, a group of disinterested people say the government is doing things the right way. Um, And all of this is to protect the defendant from overreach of the political system of the government as a whole. Now, laying these things out like this, talking about the warrants and talking about the booking and talking about the grand jury and the magistrate looking over this, all of this assumes that the people in the process are acting properly. All of this assumes that the system, right, the criminal justice system in Texas and in the country are looking to preserve people's rights as they move through this. Bad actors in every one of these cases can mess things up, right? Bad actors can cause problems. Um, and that's one of the reasons that we should be paying attention to all of these processes. We should be looking at the logs. We should be looking at what the judges are doing and the lawyers are doing and the police are doing in this process. It should always be an open to inspection by the public. Um, and at any time where the criminal justice system is hiding these processes or obscuring these processes, that's a problem, right? That's something that we need to be talking about. This is making sense. I'm trying to right bring together both the process that you see or would see if you were being arrested, and then the way each steps of these processes have uh, protections right in place or process laid out so that we know things are happening the way they're supposed to happen. Um, right, the Sixth Amendment talks about your rights as someone being brought before the criminal system, for the courts. Says that in all criminal prosecutions, the accused, right, shall enjoy the right to a speedy and public trial, right? So you shouldn't be uh, charged with something, then it be not handled for years, right? Or if bail's not issued, you are sitting in a jail cell waiting for trial for a long time. Um, so it should occur relatively quickly. Now, speedy is in the eye of the beholder. So, right, it varies what this means, but um, when the founders were writing about this, right, they had experience and they had knowledge of the crown arresting people and putting them into a jail cell and then them never being brought to trial. So they weren't ever found guilty, but they were still kind of disappeared in that sense. And maybe people knew they were there, maybe they didn't. Um, you're also guaranteed the right to a public trial. Um, so anything coming through right the justice system from the federal courts down to the state courts and county and on down, all of that must be a public process, right? We should be anybody at any time should be able to see what the state is doing, right? So um, now the other element of this is right. Not only is it should be an impartial jury, um, but it should be one that is drawn out of the area where the crime was committed. Um, right. So what you're trying to do is twofold in this point. You're trying to make sure that the state is not building a jury somewhere else that they're going to subject you to, but they're also trying to make sure that you, as the accused, while you get an impartial jury, right, you're going to be tried by one that is understanding of where these events occurred and what the impact was and who was impacted and maybe who you are, right? You're going to, it is, a jury of your peers in the place where the action occurred. Um, so you're going to, right, try this where you can. Now, there's some exceptions to this. If at some point, right, it becomes clear that there is not the ability to draw an impartial jury. Right, there are provisions in place to allow the government as a whole to move a trial to a non-biased area, so that the accused can be tried by right, a non-biased group or an impartial group at least. We're not going to go into that, but there are some exceptions to how these work. If they're not working well, they're not going to preserve the impartiality of the trial. Right, the accused shall enjoy the right to be informed of the nature and the cause of the accusations. Right, you get the they're going to charge you and they're going to tell you here's what we're accusing you of. They have the right to both confront witnesses, right? To there's not going to be private testimony that you don't get to as an individual uh, review and bring those witnesses to bear and question them in public. Um, so we're again trying to make sure that the doors are open, the windows are open, the sunlight shining in on this whole process. Um, and so, right, they're going to get the same witnesses. They're going to be able um, to cross-examine or just talk in court to those witnesses, try to see, right, what the case can be. And then the final thing here is that you have the right to an assistance of counsel. In other words, our law is fairly complex. Our procedures are long and laborious and convoluted. And you need someone, everyone needs someone, and they're going through this process that has a professional understanding of what's going on, what the law means, how it's applied, what the processes are in court. And so every person has a right to assistance of counsel. In other words, an attorney to work for you. Because obviously there will be an attorney working against you. And so in that sense, um, right, we have made, and this again is one of those things listed in the Miranda rights, we have made it required that uh, defense will be provided, counsel will be provided if you can't afford it. Quick note on this, if you can afford your own counsel, pay for it, right? Um, the folks that are doing this pro bono work in defense for indigent, those that are indigent and accused of crimes, there are not enough of them. They do not have enough time. They do not get compensated uh, comparatively for what they're doing. And while they do know the law for the most part, they may not know be experts in the part of criminal law that you're being charged with. And so, in a real sense, you get what's available, which is better than nothing. But certainly, if you can go out and right afford to find your own attorney and someone that can specializes in what you're going through, that's a better case for you, and you should do that. But understand if you can't, you have the right to counsel, right, and it'll be provided for you. Um, and I don't want to denigrate people doing that work. It's meeting a need and it's necessary. Um, but seriously, the system right now is such that those folks just do not have enough time or resources to do the best job. Um, and a lot of them are volunteering um, their time. And in that sense, I don't mean they're doing the work for free. There is, all right, a set compensation that goes to them, but these folks are not necessarily criminal defense attorneys, right? They may do something else as an attorney to make a living, but they volunteer their time to come in and try and ensure that people that need counsel get counsel. So that and that's a big deal, right? But this the Sixth Amendment, right, as you're seeing here, lays these things out for us, telling us what's going to go forward and how that's supposed to work. Okay, I am about to lose my voice again, and I have another lecture coming up, so I'm going to stop while I still have it, and we'll get back on this on Wednesday. Are there any questions? All right. Um, Seeing none, you're welcome. We'll call it a day, stop recording, and I'll see you guys